Welcome back to my channel Rahul Kunda Study. In this video, we'll talk about the family law जो LLB कोर्स में फर्स्ट सेमेस्टर में पढ़नी होती है. Basically regarding the Hindu law. Okay. So guys, before we move ahead, please subscribe, like, share this channel. You can also join my Telegram channel Rahul Kunda Study and also a group there on Telegram namely Rahul Kunda Study. I will share this PDF in my Telegram channel. Okay guys, let's move ahead. I'm going to read and make you understand what is the meaning of Hindu marriage and some acts are there for Hindu law. So move ahead guys. पार्ट वन में पढ़ेंगे इवोल्यूशन ऑफ लॉ ऑफ मैरिज एंड डाइवोर्स फ्रॉम सैक्रामेंटल मैरिज टू डाइवोर्स ऑन irretrievable breakdown of marriage. Okay, under the codifying acts, namely Hindu Marriage Act 1955, the Hindu Succession Act 1956, the Hindu Minority and Guardianship Act 1956, and the Hindu Adoption and Maintenance Act 1956. The orthodox concept of term Hindu has undergone a radical change and it has been given an extended meaning. These acts apply not only to Hindus by birth or religion, that is converts to Hinduism, but also to a large number of other persons. That person could be Buddhism, Sikhism, etc. Hindus have perhaps from the very beginning of civilization regards marriage as a sacrament, as a tie which once tied cannot be untied. The Hindu notion of sacramental marriage differs from that of Christian inasmuch as the Hindu regards their marriage not merely as sacrosanct and inviolable union, but also an internal union. The meaning of internal union I am going to read. A union which subsists not merely during the life but for all lives to come. Direct puts it succinctly thus: the intention of the sacrament is to make husband and wife one, physically or psychically, for secular and spiritual purposes, for this life and for afterlives. The great Hindu sage Manu declared, ये मनु में कहा गया है. Okay, the husband is declared to be one with the wife, neither by sale or nor by repudiation. Is a wife released from her husband once, only once is a maiden gift in marriage. The injunction is: may mutual fidelity continue till death. Marriage is essential samskar for the all Hindu. You know all that marriage. What is marriage? We can say कि marriage is a sanskar for all Hindu. Every Hindu is enjoined to marry, to enter the grihasth ashram. You can say grihasth जीवन. Okay. Manu declared, Manu में कहा गया. Okay. To be mothers were women created and to be fathers men. The Vedas ordain the dharma must be practiced by man together with his wife. He only a perfect man who consists his wife. Any man when become perfect, we can say that man perfect but the condition is he has a wife as per the Manu declared himself and his offspring. Okay, next chapter number concept of marriage and divorce. Chapter number 1. Husband and wife are enjoined to live in perpetual love, bliss, and happiness. A passage in Rig Veda runs Bido wife, Bido, and means wife, mother of my heroic children devoted to gods, Bido queen in the father in law's households. May all gods unite the hearts of us two into one. The wife is not just Patni. The meaning of wife, you can say, the wife is not just Patni but Dharma Patni. Dharma Patni means partner in the performances of duty, spiritual, religious, others. Okay, among the Hindus, there are many yagnas. Yagnas means religious and spiritual sacrifices, rites, and ceremonies. Okay, which is which a man without a wife cannot perform. Yagnas cannot perform a man without wife. Okay, together will perform. That is wife is called Dharmapatni. She is Ardhangni, half her husband. Ardhangni means half her husband. Okay. The concept of unity of personality in Hindu law is at higher plane because a wife is not merely the source of earth and kama. Okay. I'm going to read again. In Hindu law is at higher plane because a wife is not merely the source of earth and kama but also of dharma and moksha. Okay, the Vedas have ordained that dharma must be practiced by a together with his wife. Okay, according to the Vedas, marriage is a union of bones with bones, flesh with flesh, skin with skin. The husband and wife becomes as if they were a one person. Okay. In the Dharma Shastra, the husband is referred to by several designations. He is also as Bharta, Bharta, because he is to support his wife. Okay, he is known as Pati because he is to protect her. Pati मतलब क्या है? Protection of his wife. Okay. Similarly, wife has several names. She is called Jaya because one's own self is begotten to on her. She is Grihani, the lady of the house. Sachiva, wise counselor. Sakhi, confident. She is the dearest disciple of her husband. In his pursuits, she is Grihalakshmi, Samrajni, and Ardhangni. So, guys, we can see the synonyms of wife as per her Ardhangni, Chaya, Sakhi, Grihalakshmi, Patni, Dharmapatni. These name we can refer to wife. Okay, and the meaning of different, but person is one. Thus, Hindus conceived their marriage as a sacramental union as a holy union and not as a contract. Okay, the Hindu marriage is not a contract in respect of Muslim marriage. It's a sacramental union. Okay, next. For a Hindu marriage, a mandatory so that he can discharge his debt to her ancestor purpose. The debt of beginning of spring. Marriage is also obligatory because a man cannot perform his religious and spiritual duties. Okay. Okay, let's read again the line. Thus, the Hindu conceived their marriage as sacramental union, as a holy union, and not as a contract. Okay, for a Hindu, marriage is mandatory so that he can discharge his debt to his ancestor. The debt of begetting offspring. Marriage is also obligatory because without a wife, a man cannot perform his religious and spiritual duties. Okay, in sum, for a Hindu, the wife is not just patni or grihi patni, but a dharma patni and sahadharmani. In the words of Deret, in fact, in no other respect are the feeling of Hindus so acutely sensitive as when their concept of and the belief in the importance of marriage as an institution are questioned or attacked. This is largely the work of the Dharmashastra, which after more than two millennia of relentless propaganda have produced an effect which the Western world unhesitatingly labeled puritanical. Occasionally, one comes across a text or two which lay down that in certain circumstances a wife can give up her husband and take another, the nearest to divorce. This means divorce. Whenever a wife would give up her husband and take another, there are some terms condition behind that, guys. But the term divorce means what? When a wife give up her husband and take another, the nearest to divorce. The oft cited text of Narada runs as under. Another husband is ordained for woman in five calamities, namely, if the husband be unheard of, or be dead, or adopts another religious order, or be impotent and becomes an outcast. These five cases a woman can or husband can remarry. Okay. Next, similarly, these are some texts which allow the husband to renounce his wife. Tyag. Manu laid down that a husband could abandon his wife or Tyag who was blemished, afflicted with disease, or previously defiled, or given to him fraudulently It would not be correct to draw inference from these texts that Hindu law allowed divorce. In the words of Radha Vinod Par, okay, it is however doubtful whether the text in question referred to divorce in the ordinary sense of terms. Okay. Chapter 1, concept of marriage and divorce, continue. It seems that during the Smriti period, in some very exceptional cases, wife or sorry or husband were allowed to give up each other. Okay, at that time, Smriti period, husband were allowed to give up each other or wife, but law becomes more rigid in post Smriti period, and the marriage came to be established firmly as indissoluble union. Okay. However, in several castes and subcastes, divorce under custom have prevailed from an early Hindu period. Since custom derogatory to secured law are allowed to prevail, customary divorces have been recognized. Customary modes of divorce are easy. In some cases, marriage can be dissolved by mutual consent. Okay, very little formalities for forum is required. It is either a gram panchayat, community gram panchayat, or family council. Such has been importance of customary divorce in Hindu law that even after the reform and codification of Hindu law of marriage, the customary divorce continued to recognize, but customary divorce has been the privilege of the lower castes. Only in a very few high castes, divorce by custom has been available. In India, in the later period of ninth century, divorce was introduced by statute for two classes of persons: those who converted to Christianity, okay, consequent thereof their spouse refused to live with them. Whenever a husband converted to another religion like Christianity, then their wife refused to live with them. Okay, those who Christians perform Christian marriage, but divorce was not yet available to high caste Hindus. Some of them, under the impact of Western education and contact, have enlightened views preached social reform, including enactment of divorce law. Okay, although attempt of the enlightened Hindus to introduce divorce in Hindu law did not succeed at an all India level. This succeeded in an Indian state, Baroda. The ruler of Baroda and most of those who ran the state administration were enlightened people. The Baroda Hindu Lagan Vicheda Lagan Vicheda Nibandh Hindu Dissolution of Marriage Act was passed in 1931. The Baroda reforms were influenced by the then English matrimonial law and the Baroda Act of 1937, the successor of Hindu Dissolution of Marriage Act of 1931, is generally passed on the Matrimonial Causes Act 1937. The dichotomy of innocence and guilt, that is, one party guilty of the matrimonial fault and the other innocent, was mentioned. Okay, although the entitled Hindu public opinion clamored for reform of Hindu law, bearing aside a few piecemeal reform, no reform could be introduced till India became independent. Okay, two provinces of India, Bombay and Madras, being unsatisfied with the pace of reform at all India level, passed divorce laws at the provincial level in 1946. The Bombay Prevention of the Hindu Bigamous Marriage Act 1946 was passed. This was in 1947, followed by the Bombay Hindu Divorce Act 1947. In 1949, the Madras Province, and in 1952, the Saurashtra state passed similar statutes. Okay, however, attempts at reforming Hindu law and introducing divorce at all the India level continued. A breakthrough was made when in 1944 the Hindu Law Reforms Committee, under the chairmanship of Sir Bengal Narsingh Rao. In 1944, the Hindu Law Reform Committee, under the chairmanship of Sir Bengal Narsingh Rao, was constituted. The Rao Committee submitted its report in 1947 during the era of independence, okay, along with a draft Hindu Code Bill, which inter alia contained proposal for introducing divorce along with the matrimonial causes. Although the committee apparently involved a uniform Hindu code applicable to all Hindus by blending the progressive element of law, various schools of law, Hindu law. It evoked the opposition from the orthodox sections of Hindu opinion. Dr. Ambedkar, as law minister, prepared a draft code which was introduced in the interim parliament, but such was the opposition to these reforms inside and outside parliament, and it cut across party lines, that by September 1951 only four clauses could be passed. In 1951, when the parliament was dissolved, the bill lapsed. Okay. The Hindu law reforms were the between 1954 to 56 introduced the first parliament of Free India. Okay, the Hindu reforms were then between 1954 to 56 introduced in first parliament of Free India, not in the shape of one Hindu code but in the form of separate bills covering five areas of Hindu law: marriage and divorce, succession, adoption, maintenance, and minority guardianship. The rest of the Hindu law is still uncodified, and they retain all the pre-independence features. When the Rao draft code was prepared, the English Matrimonial Causes Act of 1955 was not available to us. But when the Special Marriage Bill 1954 and the Marriage Divorce Bill 1955 were introduced, this knowledge, as well as knowledge of other reforms in Eastern countries, including the Soviet Union, was copiously available to us, and we made use of this source material freely. though we retained some of our traditional views and conservative, blending them with the Western models so as to suit to our requirements in the words of Radha Krishnan. Okay. To survive, we need a revolution in our thought and outlook. From the altar of the past, we should take the living fire and not the dead ashes. Let us remember that past, be alive to present, and create future with courage in our hearts and faith in ourselves. Okay. Further, in the words of the Law Commission, Hindu law was never static. It was dynamic and was changing from time to time. The structure of any society which wants to be strong, homogeneous, progressive, must no doubt be steady but not static, stable but not stationary, and that is exactly the picture we get if we study the development of Hindu law carefully before the British rule in India. In matter of law reform for the revolution of thought, mostly English law has been made the base. Yet in reforms, the matrimonial law, a unique conservatism, has been adopted. The feeling, the psychosis is that Hindus are still a very conservative people and would not tolerate any rapid or radical reform. This feeling pervades, pervades the provisions of Hindu Marriage Act 1955. Guys, I'm going to read because it's now a marriage act about all about. In matters of law reforms for the revolution of thought, mostly English law has been made the base. Yet, in performing the matrimonial law, a unique conservatism has been adopted. The feeling, the psychosis is that the Hindus are still a very conservative people, would not tolerate any rapid and radical reform. The feeling pervades the provision of the Hindu Marriage Act. They thought that there should be a Hindu Marriage Act 1955. In the Hindu Marriage Act 1955, divorce has been founded on the guilt theory, blending it with the traditional conservatism. In the 1955 Act, the theory English traditional guilt ground visa, adultery, desertion, and cruelty were not made grounds of divorce, but in judicial separation, not adultery but living in adultery was made a ground of divorce. After the amendment of 1976, adultery, cruelty, and desertion are the ground of divorce as well as judicial separation. In Act of 1955, virulent, virulent leprosy, incurable and continuous insanity, venerable disease, all at least of 3 years duration, were made grounds of divorce. The 1976 amendments has deleted the period of all the three grounds and have rewarded incurable continuous insanity in a manner which bring it at par with English law. The ground as rewarded runs and the respondent has been incurably of unsound mind or has been suffering continuously or intermittently from mental disorder of such kind and to such extent that the petitioner cannot reasonably be expected to live with the respondent, conversion to another religion, and renunciation of the word as the ground of divorce are to be looked at in the typical background of Hindu society. Here, whereabouts of respondent not heard for the period of 7 years or presumption of death. In Hindu marriage act, guys, whenever the husband not heard around a पीरियड ऑफ 7 ईयर एज्यूम कर लिया जाता है कि वो उसका डेथ हो गया है. ओके, रेस्पोंडेंट की बात करें तो death is included as a ground of divorce in section 13 clause 1 of the Hindu Marriage Act 1955. It has been treated separately in English law. It is original act. The 8th and 9th grounds of divorce were also awarded as fault grounds. Non-compliance with a decree of restitution of conjugal rights for a period of 2 years or more by the respondent or non-resumptions of cohabitation by the respondent for a period of 2 years or more after the passing of the decree of judicial separation entitled the petitioner to sue for divorce. Okay, divorce you can see guys section 10, I guess. Okay, these were the 9 grounds of divorce under the original provisions of Hindu Marriage Act. Guys, there were 9 divorce ground when this act came into exist. Okay, the Hindu Marriage Act 1955 enacts additional grounds of divorce on which a wife alone can sue for divorce, only for wife. The pre-act polygamous marriage of the husband entitled any wife to sue for divorce. Okay, provided to the other wife or wives of the husband are alive, either are alive at a time for filing the petition. The other grounds is rape. One grounds is polygamous, that is polygamy, and another grounds rape, sodomy, or bestiality of the husband. Okay, the Marriage Laws Act Amendment Act 1976 had enacted 2 additional fault grounds for a wife if a maintenance order has been passed in favor of the wife under the section 18 of Hindu Adoption Maintenance Act 1956 or section 125 of the Code of Criminal Procedure, the 1973, and since then cohabitation has not been resumed for 1 year or upward, the wife may sue for divorce. Okay, maintenance, if the husband cannot give the maintenance period for 1 year, then the wife can sue for the divorce. Okay, guys, the other additional ground in that the marriage of the wife was solemnized before the she was 15 years. Whenever the marriage was solemnized before, if the wife is under 15 years and that she repudiated the marriage after she attained the age of 15 years but before attaining the age of 18 years, irrespective of the fact whether the marriage was consummated or not before the repudiation, the child marriage continued to valid under the law, Hindu law. Even in 1976, it could not be laid down that the child marriage is a void or voidable. Okay, it is a valid marriage under the Hindu law. What aforesaid relief has been to child wife, no relief is still provided to the child husband. The other aspect of the fault theory that is, the petitioner should be an innocent party, has been enacted in Section 23 of the Hindu Marriage Act 1955. Although we were aware that under the English matrimonial law, some bars to matrimonial relief were absolute and others were discretionary, adhering to the conservative stance. All bars have been made absolute, thus, the doctrine of strict proof has been enacted, taking advantage of one's own wrong. Or after the reform of 1976, this bar does not apply when petition is on ground of respondent's insanity, accessories, accessory convenience, conditions, collusion, improper delay, and the residuary bar visa, any other legal ground on the which relief may be refused. Courts in India have applied these bars with the same rigidity with which the English judge applied them in the late 19th century, early 20th century. Keeping off with our conservatism, which did not enact divorce by mutual consent in the Hindu Marriage Act 1955, though we did enact it as the basis of divorce a year earlier. In the Special Marriage Act 1954, which provides facility of a civil marriage between any two persons, that is, belonging to any community, religion, nationality, or domicile. The Special Marriage Act 1954 was enacted for the educated, sophisticated, and enlightened urban based gentlemen and ladies, while the Hindu Marriage Act 1955 was meant for the vast Hindu masses who still nurtured the cherished Hindu orthodoxy. But in 1976, it was thought that it was safe to introduce divorce by mutual consent for Hindu too. Now, divorce by mutual consent can be obtained if their joint petition have has joint petition husband and wife so that they have been living separately for a period of 1 year, that they have not been able to live together, and that they have mutually agreed to live separately. Guys, you can sue uh, judicial separation. For judicial separation, you have to live 1 year from your marriage date. Then you can sue for divorce. Before, within 1 year period, you can't sue. With a view of to avoiding hastily divorce, it has been laid down that after the presentation of the petition, the parties have to wait for 6 months, though not more than 18 months, and then to move a motion in court that their marriage be dissolved. The court will grant them divorce only on being satisfied after the hearing the parties and after making such inquiry as it thinks fit, that the marriage has been solemnized and the averments in the petition are true. A special bar to relief in also enacted, and the court has to satisfy that the consent of either party has not been obtained by force, fraud, or undue influence. By mutual consent होना चाहिए guys. Okay, in 1956, the Royal Commission of Marriage and Divorce submitted its report. Chairman Lord Merton, 8 other members of the commission expressed their opposition to divorce on breakdown. Nine other members of the commission were of the view of that traditional fault grounds should be retained, but divorce on the grounds of breakdown of marriage should also be made available to some limited extent. That is what we did by the Hindu Marriage Amendment Act 1964. The 90th member of the commission, it's 90th, not 90th, and the member of the commission, Lord Walker, expressed his view against both the divorce on fault ground and divorce mutual consent, and recommended that resolution of breakdown should be a sole mode of ending the marriage tie. The Matrimonial Causes Act 1959 of the Commonwealth of Australia provides inter alia that either party may sue for divorce if a decree for restitution of conjugal rights is not complied with for a period of 1 year. Under the Swedish marriage law 1920, apart from divorce on the ground of profound and lasting disruption, divorce could also be obtained by either party on the ground of non-resumption of cohabitation for a period of 1 year after the passing of decree of judicial separation. In 1964, armed with this knowledge of the comparative law on a private member's bill, two breakdown grounds were introduced in the Hindu matrimonial law without any ado and without much discussion. This was done by the amending subsection 1 of the section 13 of the Hindu Marriage Act 1955. Clause 8 and 9 were omitted and subsection A 1 capital A was inserted. Subsection 1 capital A lays down either party to marriage, whether solemnized before or after the commencement of this act, may also present a petition for the resolution of the marriage by decree of divorce on the ground that there has been no resumption of cohabitation as between the party to marriage of divorce marriage for a period of 2 years or upward after the passing decree of judicial separation in a proceeding to which they were parties, or that there has been no restitution of conjugal rights as between the parties to the marriage of a period of 2 years or upward after the passing of the decree for a restitution of conjugal right proceeding to which only they were parties. In 1970, an identical provision was enacted in the Separation of Marriage Act by the 1988 Amendment to the Parsi Marriage and Divorce Act 1936. Similar provision has been enacted. The 1976 amendments have introduced the period of 2 years to 1 year in both the clauses. The Parsi law also provides for a period of 1 year. The fundamental assumption of breakdown principle of divorce is that either party can sue for divorce irrespective of the fact that one or both the party are guilty of some other matrimonial offense. The dichotomy of innocence and fault is rendered redundant. Divorce is no longer regarded as a reward for marital virtue on the one side and the penalty for the marital delinquency on the other, but a default, but a defeat for both. A failure of marital two in one ship, and if marriage has irretrievably broke down, then it is better that the impetus cell is destroyed. With introduced the breakdown divorce in the existing framework of fault theory, and then and when the provisions came from interpretation, our courts looked at it in the dichotomy of fault and innocence. In some early cases, the facts were more or less these: the wife obtained a decree of restitution and the husband filed filed a petition for divorce after the lapse of the statutory period. It was established that the husband did not either make any effort to comply with the decree or in fact refused entry to wife when she knocked at his door. The courts refused to grant the petition as in their view it would amount to giving him advantage of his fundamental assumption of breakdown principle of divorce is that either party can sue for divorce, irrespective of the fact that one or both the party are guilty of some or other matrimonial offense. The dichotomy of innocence and fault is rendered redundant. Divorce is no longer regarded as a reward for marital virtue on the one side and a penalty for matrimonial delinquency on the other, but a defeat for both, a failure of the marital two in one ship. And if marriage has irritably break down, then the better that the empty cell is destroyed with the maximum fairness and minimum bitterness, distress, and humiliation. But the Hindu, but the Indian amendments of 1964 introduced the breakdown divorce in the existing framework of the fault theory, and when the provision came for the interpretation, and our court looked at it in the dichotomy of fault and innocence. In some early cases, that the facts were more or less these: the wife obtained a decree of the restitution and the husband filed a petition of divorce after the lapse of a statutory period. It was established that the husband did not either make any effort to comply with the decree or in fact refused entry to wife when she knocked at his door. The courts refused to grant the petition as their view it would amount to giving him advantage of his wife's wrong within the meaning of Section 23 subclause 1 subclause A of the Hindu Marriage Act 1955, wrong being the non-compliance with the decree. In later decision, our courts modified their positions. In Bimla Devi, daughter of Bhaktwar Singh versus, there is a case, there were case, guys. Nimimla Devi, daughter of Bhaktawar Singh versus Singh Raj, son of the Sondhi Ram. The Sondhi Ram. It was held that mere non-compliance with the decree of restitution of conjugal right or a mere declination to, to decree to an offer of reunion did not amount to a wrong disentling the petitioner to the relief. This view has been confirmed by the Supreme Court. After 1964, the English matrimonial law advanced rapidly towards divorce on the ground of breakdown of marriage. In 1966, the Mortimer Committee, appointed by the Archbishop Archbishop of Canterbury in 1964, submitted its reports and recommended that the irrevocable breakdown of marriage should be the sole ground of divorce. Irretrievable breakdown of marriage should be the sole ground of divorce. The report gave the following definition of breakdown of divorce: such failure in matrimonial relationship or such circumstances adverse to the relationship that no reasonable probably uh, remains of the spouse again living together as husband and wife for mutual comfort and support. A little later, the English Law Committee submitted its report and recommended inter alia the introduction of breakdown of marriage as a ground of the divorce. In 1969, the Divorce Law Reform Act was passed, which laid down the five criteria of breakdown of marriage, the last one being 5 years living apart by the spouse. Some bars have also been enacted, thus a petition for dissolution of marriage will result in grave financial or other hardship to him or her. It would in all circumstances be wrong to dissolve the marriage. In deciding this question, the court shall consider all the circumstances, including the conduct of the party to the marriage and the interest of those parties and interest of any children or other person concerned. We also come to note that in 1966 the Commonwealth of Australia and in 1968 the Dominion of Canada also introduced divorce on breakdown grounds. Under the law of the former 5 years continuous living separate and apart by the spouses was considered to be sufficient evidence of breakdown of marriage provided there was no likelihood of cohabitation being resumed. Under the Canadian law, the period of separation is 3 years. We are also aware of the Soviet family law of 1944 and 1968 and the Western German law 1946, which also recognized the breakdown of marriage as a ground of divorce. Under the Soviet law, the determination of an irretrievable breakdown of marriage in each individual case left to the court. Under the law of the latter, if the domestic community of the spouses has ceased to exist for 3 years and where by virtue of this deep seated and the irretrievable disruption of the matrimonial relationship and institution of committee of life responding to the nature of marriage cannot expected, either spouse may apply for divorce. With this knowledge, comparative law when in 1980 The Law Commission, our Law Commission submitted its 71st report. It chose to rely on that the English matrimonial law rather than on any other system of law, though as the period of separation it preferred the Canadian matrimonial law. The Commission has not recommended that the existing fault ground of the divorce and divorce by the mutual consent should be abolished. Rather, it is recommended the introduction of the breakdown ground along with the existing ground. The Law Commission is formulation of breakdown ground is as under. A petition for the resolution of marriage by the decree of divorce may be presented to the court by either party to a marriage on ground that the marriage has broke down irretrievably. The court hearing such a petition shall not hold the marriage to have broke down irretrievably unless it is satisfied that she parties that the parties to the marriage have lived apart for a continuous period of at least last 3 years immediately preceding the presentation of the petition. If the court is satisfied on the evidence as to the fact mentioned in subsection 2, then unless it is satisfied on all the evidence that the marriage has not broke down irretrievably, it shall subject to the provisions of this act grant a degree of divorce. In the considering of for the purpose of subsection 2 whether the period for which the parties to a marriage have lived apart has been continuous, no account shall be taken if any one period no exceeding 3 months in all, during which the parties resumed living with each other, but no period during which the parties living with each other shall count as part of period for which the party to marriage lived apart. For the purpose of subsection 2 and 4, a husband and wife shall be treated as living apart unless they are living with each other in the same household, and reference is this section to the parties to a marriage living with each other shall be constructed as reference to their living with each other in the same households. Following the English law, the bar to matrimonial relief on ground of irretrievable breakdown of marriage is recommended as under. Where the wife is respondent to a petition for the dissolution of a marriage by decree of divorce on the ground of the irretrievable breakdown of marriage, she may oppose to grant of a decree on the ground that the dissolution of marriage will result in grave financial hardship to her and that it would in all the circumstances be wrong to dissolve the marriage. Where the grant of a decree is opposed by a virtue of this provision, then if the court finds that the petitioner is entitled to rely on the irretrievable breakdown of marriage, and if apart from this provision the court would grant a decree on petition, the court shall consider all the circumstances including the conduct of the parties to the marriage and the interest of those parties and of any children or other persons concerned, and if the court is of opinion that the dissolution of the marriage will result to grave financial hardship to the respondent, and that it would in all the circumstances be wrong to dissolve the marriage. It shall dismiss the petition, or in an appropriate case stay the proceeding until arrangement have been made to its satisfaction to the eliminate the hardship. Again, following the English law, one another bar is recommended as under the court shall not pass a decree of divorce on the ground of irretrievable breakdown of marriage unless the court is satisfied that adequate provision of the maintenance of children born out of marriage referred to in subsection 2 has been made consistently with the financial capacity of the party to the marriage. This section shall apply to minor children, unmarried or widowed daughters who have not the financial resource to support themselves, and the children who, because of a special condition of their physical or mental health, need looking after and do not have the financial resource to support themselves. Okay, the Law Commission has to recommended that the Section 23 is subclause 1, subclause A of the Hindu Marriage Act 1955 should not apply the breakdown principles according to the Law Commission. It is desirable that the petition on the ground of irretrievable breakdown of marriage would be excluded from the scope of Section 23, subclause 1, subclause A. The Commission added once divorce is decided to the granted on the basis of the irretrievable breakdown of the marriage. Any allegation that the fault of a party contributed to the condition leading to the breakdown should be regarded as irrelevant. The recommendation of the Law Commission has been accepted by the Government of India and a bill was introduced in Parliament, but an account of opposition to the bill by certain organization of women, it was allowed to lapse. So this was all about the guys divorce. In next part I will continue to read concept of marriage. Okay, thank you so much for watching this video. Bye bye, take care, have a nice day, be safe.